So with that said, I will turn it over to Doug. Doug is an attorney with the Center for Arkansas Legal Services, and he is going to talk to you today about Chapter 7 Consumer Bankruptcies.
Hello, everybody. Happy Friday lunchtime. It's almost the end of the week. Almost time to go home. So, but Christy, did you have a poll that you wanted to do at the very beginning, or?
Yes, thank you for reminding me.
All right.
Okay, everyone, here's your first poll question. And again, please participate because this is one of the ways we monitor your attendance. So where do you send your forms for CLE credit? And you can't get this one wrong.
And
oh, I'm sorry, I didn't launch it. I thought I did.
Oh, I was about to say, I'm like, it doesn't come to me.
I love that you guys are having fun with it and picking different same answers. Okay, I'm going to end that poll, but again, please just remember to send your forms to the right place.
All right, so here we go. I'm Doug Cortés, and I am sometimes referred to as the senior bankruptcy attorney at the Center for Arkansas Legal Services, and sometimes referred to as many other things. But my favorite thing I'm referred to here is bankruptcy geek. So I've been doing this a while, and I'm really into it, and which works out well for my clients. And now I get to give my spiel for the Center for Arkansas Legal Services, and so here goes. The Center for Arkansas Legal Services works to defend the legal rights of low-income individuals. We focus on improving economic stability, protecting families and children, ensuring habitable, affordable housing, and advocating for the needs of vulnerable populations and communities. We continue to look for ways to reach low-income individuals where they are at, even during this pandemic, to help ensure that they have access to legal representation. If you would like to see what we do, or if you want to visit or sign up as a pro bono attorney with us, then visit arkansaslegal.org. You may be in another part of the state where Legal Aid of Arkansas is. And so, you can contact them, you can go through our website, contact us, contact them. We're basically, like sister organizations, and, they would appreciate the help as well. So this slide has been up long enough, so it doesn't matter that much, but there's some information about me if you're interested. If you have the slides, that's great. All right, so what we're going to talk about, and I want to kind of get rolling, because really Chapter 7, we're just going to talk about Chapter 7. These are the kind of highlights, things that I'll be talking about today. Again, if you have some questions, then put it on the Q&A tab. Don't if you've got comments, you're welcome to make comments to each other on the comment section, but put the question in the Q&A, and Christy will make sure that I get those. But this is going to be, we're not drilling down. I mean, this is a 1-hour CLE. Chapter 7, I had one of our junior attorneys here do a CLE presentation. Participant, not as a presenter, but he took a CLE from the Practicing Law Institute. If you're not familiar with that, and it's like 6 hours long, and that is just on Chapter 7. But this is really, the intention is, if you're thinking about maybe getting into bankruptcy, or it's good for issue spotting, maybe you do family law or criminal law or things like that, and you're like, what are the kind of things that I need to be aware of in my practice? I'm not necessarily wanting to file bankruptcy. Or if you're just here for an hour of CLE, then we're happy to have you. Maybe you'll learn something along the way. So general overview of bankruptcy. It's an organized system under federal law to allow the honest but unfortunate debtor to get a fresh start. And so this goes back, I put a site there. I'm generally not going to have a lot of sites. I might cite some, just a bankruptcy code or something like that for broad, again, just kind of broad strokes. But this is something that goes way, way back. I mean, the bankruptcy, really the standing bankruptcy laws in the United States started before 1900 and the late 1800s. Before that, they just kind of came and went. But finally, Congress got around to deciding, look, it's something we need to have there all the time. And so people have a mechanism under federal law, states have those like receiverships and things like that to deal with it on a state level, but this is a federal law, and it's under the United States Constitution that, Congress can pass uniform laws of bankruptcy. So they passed bankruptcy laws, and so we've had them since then. They did a huge change in the laws So if you ever are doing some research on cases, be careful for cases like, that are before about 1980, because then they overhauled the bankruptcy code and have what we to have what we have today. And the super largest things that we'll talk about are automatic stay, which that starts when you file bankruptcy, a discharge, which is really, that's kind of holy grail. That's where you want to get. That's the goal the client is seeking, is to discharge their debts. And property of the estate and exemptions, that's, protecting their assets and things. And a major player in the game is trustees. And so we have two types of trustees. There's a Chapter 7 trustee, who they are panel trustees. They are here, mostly they're attorneys. They don't have to be attorneys, but most of them are attorneys, and they're basically like administrators over the bankruptcy case. And then they have the Office of the United States Trustee, which is part of the Department of Justice, and they oversees, so I'll call them the case trustee or the Chapter 7 trustee. They oversee those programs. There's also another chapter in bankruptcy, and we'll talk more about chapters in a moment. But so you might have heard people talk about filing a Chapter 13 bankruptcy, and that's different than a Chapter 7. But consumers file generally 7s or 13s. Sources of law for bankruptcy. So this is the majority of it. Again, we have the Bankruptcy Code, which is Title 11. Then we have bankruptcy rules. Much of those mirror federal rules of civil procedure. So if you're familiar with the federal rules, then you got to pay attention, because a lot of the rules in bankruptcy might say, yeah, we use rule whatever 56, but here's some tweaks on it. So you'll find those in the rules, and there's a lot of rules. Bankruptcy is very administratively heavy kind of law and practice, and so you're just constantly with the bankruptcy code and the rules. Federal rules of evidence are what we use in as well. They're just the straight federal rules of evidence. There's no particular ones that are for the bankruptcy. And then, as far as precedent goes, we follow, generally federal courts. So, we have the Supreme Court of the United States, we've got a U.S. Court of Appeal under that. And then below that, we kind of have a split. There's something called a bankruptcy appellate panel or federal district courts. And then you have bankruptcy court. So what happens is you file your case in bankruptcy court, you get a motion or a ruling or your judgment, or, something happens in bankruptcy court, you want to appeal it, you can choose to either go to the federal district court, or you can go to a bankruptcy appellate panel. And what a bankruptcy appellate panel is, it's just 3 judges who are appointed by the 8th Circuit Court of Appeals. And that 3-judge panel will sit and they will do the appeal. And then, if you disagree with we call it a BAP. If you disagree with the BAP, then you appeal it to the court of, to the 8th Circuit and then up to the Supreme Court. Bankruptcy courts get their jurisdiction from actually a different section under the United States Code, and that's 28 USC. So it's 1334 and 157. So those will come into play a lot. And then there's other federal and state laws, So when you're in bankruptcy, the thing I like about bankruptcy a lot is I get to be kind of a guru in bankruptcy, but I also get to dabble around in all kinds of other stuff, whether it's contract law, property law, just everything you can imagine. I've worked on, national trucking companies and chicken farms and just all kinds of cases that are out there. And also, when you're doing bankruptcy, you're dealing with property of the estate, and you're dealing with debts, and you're dealing with assets and things. And almost all of that is determined under state law. So, if you're talking about a mortgage, then, what does the Arkansas Supreme Court say about how you can do this or not do that? So, that the bankruptcy judge will literally look straight to that, and then to the Arkansas, Supreme Court, or whatever Arkansas court, and they'll say, hey, this is the way it works in Arkansas, and this is what we're going to apply in this bankruptcy case. So, and I mentioned it's like, there's different kind of chapters that you can file under the bankruptcy code, which is divided up into like Chapter 1, 3, and 5. And those are, administrative. Like 101 is, typically it's definitions. And, there's Chapter 3 and Chapter 5, and those apply to all the rest of the chapters. Chapter 7, 9, 11, 12, 13, those are the chapters that a bankruptcy would be filed under. So if you hear about a big corporation, they file bankruptcy and they're doing a reorganization, that's 11. individuals, would file under Chapter 7 or 13. But again, we're going to focus on 13. What 13, traditionally, they call it a liquidation or a straight bankruptcy. And what they mean is, imagine if we didn't have exemptions or anything like that, then, you would file bankruptcy and the trustee would come in, they would collect all of the property and they would sell it all and they would just give it to the creditors. But, we have exemptions and other things to be able to protect the property. So at least with my clients here at Legal Aid, it's extremely rare that they lose any property. When I was in private practice, sometimes there's some people that have a lot of stuff and they'll either have to turn it over to the trustee or at least give him or her some money to pay for the difference on what that is. And we'll talk more about exemptions and properties a little bit later. Another key thing is in order to file a Chapter 7, they have to pass a means test to qualify. And I'll talk a little bit more about the means test later, but basically you have to be under the median income for the state that you're in order to even qualify. It doesn't mean you're necessarily going to file a 7, but in order to qualify, you have to do that. Also, Chapter 7, the main point of Chapter 7 is discharging unsecured debt. So, credit card debts and medical bills and things like that. It also gives you a means of dealing with secured debt, but not the same as I mentioned, the Chapter 13. And the Chapter 13 has a payment plan where, the 13 is all about getting caught up. If you get behind on your mortgage and you want to keep your house, if you get behind on your car payment, you want to keep your house. Chapter 13 has a mechanism to deal with those arrearages and get those paid off so that by the end of the Chapter 13, you're caught up. Chapter 7 doesn't do that. When you file Chapter 7 and you have a car and you want to keep it, you have to be current on your car. So we'll talk about dealing with secured debt in a few minutes. All right, so one of the biggest things about filing a bankruptcy case is the automatic stay. And most people, even if they only have heard very little about bankruptcy, hopefully, especially if you're a practicing attorney, you're familiar with the automatic stay. So that's under Section 362. And basically it stops. It's an injunction that automatically happens as soon as the case is filed. It doesn't require the judge to look at anything. You file a bankruptcy petition and the creditors have to stop trying collection. So even if, for example, they get a writ of possession and they're trying to evict someone from a rental property and the sheriff goes out there and serves it on them, then there's an automatic stay, it's in place. And, that stops it. They can come in and, you can change it. They can ask the lenders can come in and ask for modification or whatever, but when you file it, there's no other need for anything. The automatic stay just kicks in. Some of the exceptions to it, the automatic stay include criminal proceedings. It doesn't stop. If you're, if you have a client and you're doing, criminal law, you probably are familiar with this, hopefully, but the criminal case is still going to go forward, the judge and the court and everything. Domestic relations. So if you're in family court and someone files a bankruptcy, normally they will either file a suggestion of bankruptcy or a notice of bankruptcy or send it to the attorney or the court or something to let the family court know, but they're not going to stop the proceedings. However, a key thing about family law is when that debtor filed their bankruptcy case, it created this estate. And now the estate is no longer, the property really belongs to the estate. So the property division, when you do a property settlement agreement in family law, that has to be approved by the bankruptcy court. And there's all kinds of fights in my career. I've seen bankruptcy judges and family court judges like basically yelling at each other in court before. But that's the way it works. The bankruptcy courts are like, hey, we're federal law, we trump state law, and we say there's an injunction, you can't deal with any of this property of the state. And all the cases all over the country always support that. So, if you have a property division, you need to be in touch with, and one of the parties, especially if your client, you need to call their bankruptcy attorney, and they generally deal like that. So violations of the stay, if someone violates automatic stay, let's say there's a creditor and they were trying to repo a car and they come, you file bankruptcy today and tomorrow the repo man comes, picks up the car and takes it away, then those that is void. And so they have to undo it. They have to unwind it. And if they do it intentionally, you can get punitive damages for it. You can generally get damages if there are damages. Sometimes there's damages that get incurred from violation of the stay, but most of the time, in my experience, it's just a matter of they didn't get notice yet. The judge isn't going to slam them for they hadn't received the notice yet, and it was just the next day and they got it repoed. They didn't it was kind of like give them the car back and we'll call it even. But a court can terminate or modify the automatic stay. Generally, creditors, and I used to represent lenders, they will file a motion for relief from stay, or a motion to lift stay, or a motion to modify the stay. There's a lot of different languages. I kind of shorten it to MFR, excuse me, motion for relief. So they file it and they ask the court if the court will change the stay to, or just get rid of the stay and allow them, for example, to come repo the car. Or continue with the mortgage. Maybe the client's like, hey, I'm not staying in the house, I just want to surrender the house, and so they can ask for that. So let's see if Christy, if you can give, I think I had a poll up, one of the first polls that I had sent to you, if you can do that one.
Yeah, I'm so sorry I missed that. I was trying to answer some of these questions. I totally missed my cue to put that question up.
Oh no, thanks, I appreciate you answering questions. While she's putting that poll up, let me look real quick. Oh yeah, this was just this first poll. It's just to give me an idea. I just wanted to have an idea how many bankruptcies, if anybody had filed them. If you're a bankruptcy attorney, unlike me, hopefully you are doing, today is the day they're doing the big kind of annual CLE with the Arkansas bar for the debtor creditor deal that happens every year. But I see right now, it looks like a very large percentage of you have done 0 or 10 or less. So that's good. I just wanted to make sure I'm talking to the right, kind of level. And for those of you that are putting too many to count, too many to recall out there, feel free to correct me. I don't have any problem with that. I'd rather somebody correct me, and that way I don't keep doing things wrong. But give me a shout. So and let me look. It looks like there's a question that says, sounded like you filed bankruptcies. I didn't think legal aid provided this type of work for its clients. We do. I do chapter 13s and I do chapter 7 cases. We mostly do probably chapter 7s. If it's a 13, like I said, those have a plan. And in order to, if you're going to get caught up on your house payments and get caught up on your arrearages and stuff like that, you probably need to be making enough money so that really you could hire a private attorney. If it's a super mess case that I just from my personal experience of practicing private attorney for a long time, know that it's, they don't really, it's not a kind of case that a private attorney is going to be too crazy about, then I'll deal with those kind of things. But I'll send them out. So get signed up. If you want to get some chapter 13 cases, we'll send them out pro bono. You can still get pro bono credit for them, and you can still charge the no look fees on those. So for those of you that are doing 13s, just want to let you know about that. So let's see, where were we on automatic stay? Let's go to the next screen. So when you file a bankruptcy, you're going to file a bunch of petition schedules. And like I said before, there's a means test that they have to pay to pass in order to qualify for a chapter 7. And a lot of times bankruptcy attorneys will say petition, and maybe they mean just the petition, which is like the first, I think it's 9 pages. And then there's a bunch of schedules. The schedule, it used to be A, B, C, but now they join them. It's like A, B, and then C, and then they kind of combine them like that. There's another thing called a statement of financial affairs. There's that means test. There's some other documents. Statement of intention that has to do with if rentals, executory contracts. I'm going to get too much into that, but executory contract, like a lease or rental agreement, it's basically a kind of contract that requires, there's still some obligations on both sides of the contract to do. You got to say what you're going to do. The debtor has to say, hey, I have this car lease. I want to keep the car lease, or I don't want to keep it. And there's some other documents about attorney's fees. And then at the end, it's probably at least 50 pages. And if there's a lot of creditors, you might have a lot more, but so there's a lot of pages. So you file that, and that's what you use to begin your case. So it was, let's see, the means test. So what the means test is average income over a 6-month period. So you have to collect a giant pile of documents from your clients. Things like tax returns and 6 months, really more than 6 months, but at least 6 months of pay stubs and, the driver's license, social security card, forms of identification, anything about their loan documents. You got to pull credit reports for them and all this. And so you put in, you get this income and then you average it out. You take the average income over a 6-month period. And really, I haven't done a means test manually other than in a course sometime many years ago. I don't know. We just use software because it's just bankruptcy cases are way too complicated to do without using software. But you put in the numbers in the means test and it looks and it says, hey, your average income over the last 6 months is below the state median, therefore you qualify for a Chapter 7 case. Or if there's some ways that I'm not going to get into the details, but you might be a little bit over and there's some adjustments you can make. But one of the things that's not included in the means test is you totally don't include Social Security income. So whether it's retirement or disability from Social Security. And also recently in 2019, they passed the Haven Act. And so now VA disability benefits are excluded from the means test. So let's say you have, 2 spouses and they, one of them works for a living, has a job, and the other one is, living off the VA disability or living off of Social Security, is retired and living off Social Security. And, otherwise, if you counted that as income, they would have to file a Chapter 13. They couldn't file a Chapter 7, but that totally gets excluded. And then you're totally exempt from the means test, though, if the majority of your debt is non-consumer debt, or if you're a disabled veteran and incurred most of the debt while you're on active duty, or there's some things about National Guard or reservists when they get called to active duty and there's a certain amount of time that you can qualify for a Chapter 7. But the one about the majority of if it's non-consumer debt, so, if they had a business, for example, and they have a lot of debt, but that debt just has to do with that business. Maybe they ran up a bunch of credit cards, but they're not really there. They're not buying stuff at Sam's and Walmart and wherever. They're buying stuff, that was things that they used. They had a wrecker service or some kind of service they provided, and all of that debt was racked up. You look at it, and if more than 50% of it is not consumer debt, or the majority of it is not consumer debt, then they don't even have to do the means test. They can just file a Chapter 7. Let's see, there's a question asking me if I saw an HBO bankruptcy 2 weeks ago. Oh, John Oliver on HBO. I think I saw that. I don't remember, but I have to go back and look at that. I appreciate it. When was means started? So the means test technically started, there was a BAP-CPA, was a Bankruptcy Abuse Prevention and Consumer Protection Act that was enacted in went active in late 2005. Before that, they didn't have this technical means test, but courts used something like that. And they would say it was basically an abuse for you to file Chapter 7 under certain circumstances. So basically, they just kind of nationalized and said, this is what we're going to do. And so, all right, so let's continue. I know there's a bunch of questions, but let me get through a couple more and then I'll go back to those. So, like I said, the case is commenced by filing a voluntary Chapter 7 petition. And in rare cases, they can be started by someone filing an involuntary petition. So if some creditors get together and they say, hey, we need to force this person into bankruptcy, then they can force someone into a bankruptcy. But it's extremely rare to see that, because generally creditors kind of like want to take what they can get, first come first serve, kind of race to the courthouse kind of deal. But it happens, and usually the ones that I've seen were earlier on in my career when I used to do commercial cases, Chapter 11, that kind of work, and sometimes you'd see those with big businesses. And then you can file what's called an emergency case. Like really all you have to have is you file that petition and then you have 14 days to do the schedule. So like I said, someone comes in, they're like, hey, they're doing a foreclosure on my house, tomorrow morning, first thing, I can get a bunch of information together and file an emergency petition and then get the other stuff later. They have to do a course before they can file. It's called we call it first course or credit counseling course, and I'll talk about that in a minute too. So, and then as far, it's kind of like, I liken it a little bit to probate. So, you know, an estate is created, someone dies, and then there's an estate created, and then someone's appointed to administer the estate. In our case, that would be the Chapter 7 trustee who's administering the estate. And, you know, they're there administering the estate, and they go through it, and, you know, they say, hey, if you think that they owe you any money, y'all need to send in y'all's claims. And so bankruptcy has that same thing. If you're in a Chapter 13, everybody has to send in a claim. In a Chapter 7, they don't even ask for claims. First, they find out if there's any assets, if you're above exemptions. If not, if there's something that, you know, the trustee's going to be able to sell and, you know, distribute some money to creditors, then they do that next thing. But again, especially with my clients, it's extremely rare. But even when I was in private practice, it was pretty rare. I was usually able to exempt most things, or if not, a lot of people will just do a Chapter 13, even if they could have done a Chapter 7, so they can pay that over time instead of paying it in one lump sum, unless they're able to. And then I had another question that said, do they have to be a certain percentage disabled vet? Yeah, they do, and I think it's at least 30%. I just off the top of my head, I'm trying to remember. I actually did a CLE on that not too long ago. Have I been able to use the Haven Act successfully in Chapter 7? I know it works in a 13. I personally haven't had the need for it because since this came out, I've been working for CALS, and all of my clients qualify for Chapter 13. I mean, I'm sorry, for Chapter 7, or they wouldn't even be working here with me. So let's see. PPP loan money counted in the means test. I'm not sure about that. I haven't had a chance to look at that or thought about that really. All right, those are those questions. So property of the estate. Before I do that, let's go and do another poll, Christy. I think I have another one. And while she's working on pulling that up, I'll start talking about bankruptcy. So like I said, when they file the bankruptcy, oh, here we go, there it is. So my question is, how many pro bono cases have you accepted from CALS or Legal Aid of Arkansas or any other nonprofit or other organization? I just want to get an idea of how many of you do that. And, you know, we have those available, like I said at the beginning. I mean, whether it's family law or all kinds of other things, you know, just go to arkansaslegal.org and, you know, go through there and you can sign up to be a pro bono attorney, and we can send it to you. We keep track of it. For people that do a lot of them, we have like an award ceremony and things like that. So, all right, so property of the estate. Like I said, the commencement of the bankruptcy starts that bankruptcy estate. And then all of the debtor's property, all their interest in any property, whatever it is, that, you know, so even if they have an interest in, let's say, an option, let's say they have stock options, right? They have an interest that those might have some value. They may or may not, but, you know, whatever they have an interest in, and maybe they only have a partial interest. Maybe they have an interest in, you know, a parent passed away and they already have an interest in that estate or something. You have to list all of the property that they have. And then what you want to do is you then exempt it. So the state exemptions is, you know, the one that most people know or have heard about is like a homestead exemption. So under state law, for example, in many states, there's a homestead exemption that says creditors can't basically come and, you know, throw you out of your house and take your house from you. They can maybe put a lien against your house, but they can't actually take your house from you generally. But in bankruptcy, we have those state exemptions. I used to practice, I'm from Arkansas, but I started practicing in Texas for a long time, and they have huge exemptions down there. So I almost always use state exemptions down there. But in Arkansas, the state exemptions here are, at least from a debtor's perspective, not that great, unless you just have a really lot of equity in your house and you want to protect that, but you don't have much personal property. So what happens is, so you list all of this property, and for each thing that you list on there, you say, here under the code is where I can exempt this, whether it's a retirement account or just, you know, a wild card kind of exemption that would apply, or tools of the trade, whatever kind of exemption you have. So that way, hopefully everything is covered. And in the end, the trustee says there's no money there's nothing left for me to collect. And so, just go ahead and let this guy go and get his discharge. So as long as you, list everything on there properly, then the trustee doesn't ever actually come take possession of it. It can happen. Like, for example, I've seen it happen when someone had a business, then the Chapter 7 trustee could technically, there's a way, maybe they come and they even operate the business. But I'm just talking today, we're just focusing on consumer bankruptcy things. That's more of a business 7 bankruptcy case. But if you don't list those claims on there, if you don't list all of that property, but in particular, if you don't list a claim, like a lawsuit that you have someone where you can go out and get a judgment against someone, then judicial estoppel, and there'll be standing issues that can preclude the debtor from, continuing to assert that claim. So there's cases where, they didn't list something in their bankruptcy, and then later on, that debtor goes out and sues someone. And that person says, hey, that defendant uses this as an affirmative defense. And it's like, first of all, he should be stopped from being able to do this. He didn't say that he had a claim in the bankruptcy case. But not only that, he doesn't have standing, because if you don't list it in the bankruptcy case, then it continues to be part of the bankruptcy estate. It's kind of in this limbo place. And so that debtor doesn't have standing. You need to go back to the Chapter 7 trustee, for example. So you can lose those claims. People have lost huge claims because they didn't list it that they might have been able to exempt. And then, but, if you're in a bankruptcy case and you forget to list some debt or list, whatever, then it's possible. You can pretty freely amend your schedules, with the exception if, there's some hanky-panky going on and it becomes apparent that you're just changing them because you're trying to commit fraud. And we'll talk about non-dischargeability in a little bit. All right. So after you file the bankruptcy case, one of the first things that the court does is will set what is called a meeting of creditors. If you hear bankruptcy people talking, they might say a MOC for meeting of creditors. You might hear them say a 341A meeting or a 341 meeting. And basically what happens is that Chapter 7 trustee has to conduct a meeting in person with the debtors. And if it's a joint case, like a husband and wife, both of them have to be there. They have to present their ID, proof of social security card. And then they're going to be asked a series of questions by the trustee that are, it's just the same, about 15 or so questions. Almost all of them are just yes or no questions. I included a link here. If you got these materials, you can go and download. That's the ones that I mentioned, the United States Trustee Office of the Department of Justice. They administer, or they oversee the Chapter 7 trustees. There's a list of questions that the U.S. trustee says you have to ask these questions. And those are, the questions that may come up. Some of them towards the end are maybe optional, depending upon what's going on. So then after they go in, and literally it takes a little while for the meeting to happen. There might be a lot of people there, but eventually you get to the meeting and you go up in front of the trustee, and it takes like 2 to 3 minutes for them to say, raise your right hand, you're sworn in. It is under oath. So you swear or affirm to tell the truth, whole truth, nothing but the truth. It's not going to happen in court, although it might happen in a court building. Like if you go to Helena, it's at the federal courthouse down there, and Hot Springs at the federal courthouse down there. Here where I am in Little Rock, they hold it at the Bank of America building, which is where the United States Trustee's office is. And the same way when I practiced in Texas, usually it was either in some specific, building where the U.S. Trustee office was, or in remote locations, it would be like in that federal court somewhere, maybe in a side room, sometimes in the courthouse room. But there's not going to be a judge. So one of the things I always have to put them, it's like, you don't have to wear your best clothes, or, when you go to court, I need you to, Sunday best. Whenever we go to the meeting of creditors, it's fine. If you need to go to work, wear your uniform and show up, we'll do the meeting and get out, and that's fine. During the pandemic, we've been doing them by the phone. But that probably will stop at some point, and we'll go back to doing live meetings again. All right, so I mentioned about discharge and dischargeability. Discharge, that's the holy grail. And for a Chapter 7 case, that happens pursuant to Section 727. So you have to meet all of these criteria that are in 727 in order for you to get your discharge. And again, that whole thing about the discharge is, the honest, debtor, but an unfortunate debtor who gets a fresh start. They get rid of the debts that they can discharge, but there's certain debts that either they're just not discharged because the bankruptcy code said this kind of debt isn't discharged, or they're not dischargeable if the other party takes some kind of action. So, and what is a discharge? A discharge really is a legal, it gets rid of the legal obligation to pay the debt. It doesn't, it's a little bit like a statute of limitation, but it's way more than that, in the sense that, you can't sue me over this debt anymore, but it's still out there. But really, that's just kind of esoteric. I mean, really, so as far as just how does it function in the real world, they have to take it off the credit report. They have to put like the debt owed is 0, and they can put on the credit report a line that says, discharge in bankruptcy or something like that. And there's an automatic stay when you file a bankruptcy case, but then at the end of the bankruptcy case, there's what's called a discharge injunction. And the discharge injunction is what prevents the creditors from coming back and trying to collect the discharge debt. And again, it's, violations of that can be punishable. There's a bunch of case law on it. And when it really, what generally happens with me is something along the lines of, if someone, I'll write them a letter. It says like, hey, you tried to collect the debt from this person, stop, cease and desist kind of letter. And then if they don't stop, then, we'll look into whether there's a case to file against them or not. Only pre-petition debts may be discharged, and I should have put an asterisk there, but filing the petition is kind of the bright line. There is a little bit of a difference. Like if someone filed a Chapter 13 and they converted to a Chapter 7, there can be some post-petition debts that get discharged. But just, as far as this, we're, like I said, we're looking at sky-high level, not drilling really, really down. But basically, all the debts that they listed on there. So you file a Chapter 7, 3 weeks later, you go get a new medical bill. Well, that bill's not going to be dischargeable, but the medical bill from the week before you filed, that'll get discharged. And so, as I said, there's some debts that just automatically, they're just accepted from discharge according to the terms of the bankruptcy code. I say most taxes, it depends on the criteria, but there's a general exception to that. So like if they are more than 3 years before you filed your bankruptcy petition, they were assessed more than 240 days before you file your bankruptcy petition, and those taxes were, on an income tax that person filed on time when they were supposed to file it, that's kind of an exception. And there's a lot of, it's way more complicated than that. But so it's possible to get some kind of taxes sometimes to be exempted. I'm talking about income taxes. If you have like sales tax, those are trust fund taxes, for example. Like someone has a business and they owe DF&A sales tax, those, it doesn't matter. Those are not dischargeable. Those are, they're not really that person's funds to begin with, their trust fund tax. So, what I generally tell clients is, just assume taxes are not dischargeable. Then I take a look at them after the fact and see what's going on. And it's rare for me to find someone, honestly, who filed their taxes on term and met all that criteria to get them discharged, but it does happen. Student loans, they're not dischargeable. It's just by automatically, they're not dischargeable. There is a way to get a discharge on them, and it's a mountain of a hurdle to leap over to get it. A lot of times it's easier to get a discharge like through the Department of Education if it's a government kind of student loan. There's a case out of the Fifth Circuit actually recently, or within the last few years, that said private student loans, even after the change of law a few years ago, are discharged in bankruptcy. But we're in the Eighth Circuit. Eighth Circuit hasn't said that. So if you live in Arkansas and you just have a truckload of student loan debt, consider moving to Texas or Louisiana or Mississippi maybe. But generally, student loans can't get discharged. I worked on cases where people gotten them discharged. It's usually, they're elderly, they're never going to work again. They, barely have any income. They're on Social Security. They got all kinds of medical problems. I think it's too much that too many hurdles they have to jump through, but it happens sometimes. Also, most fines and penalties owed to government entities. So criminal restitution, that doesn't get discharged. But if it's restitution simply for like something that you're reimbursing the government for something that they incurred, and I don't remember the last time I saw one of these, but the classic example is, you get fined $50 and you live in a town where they say you got to keep your lawn cut or something like that, and you get fined $50 for it. That's a criminal fine, but then they send you another bill, a little bit later for $250 for going out there and mowing it. And that's just to pay for the mowing thing. That one can get discharged. But generally, if it's, criminal fines are generally not dischargeable. Some more automatic exceptions if it's related to, like DUIs, DWIs, debts that you don't list. So in chapter 13, if you don't list a debt, it doesn't get discharged, period. In a chapter 7, if it's a no asset case. So like I said, if you're able to use exemptions and you're able to get everything taken care of, you don't have anything left over that the trustee is going to be able to go grab and sell, then even if you didn't list the debt, you're like, oh, I forgot Dr. So-and-so to put him on there. I've had clients call me a year later and they're like, oh, I didn't put this on the thing. I'm like, well, it's okay. It's your case was a no asset case. There wasn't anything the trustee didn't send out a notice for people to file proof of claim. In that case, go ahead and get discharged, and it's not a problem. So exceptions that are not automatic, and these are generally based on bad actions, it's fraud kind of stuff. And so those are under 523. There's other things that can go on, but like I said, just as a global thing, by far the most ones that get filed are 523A2. That's just, debts that are incurred by fraud, just, your regular kind of fraud. There's also 523A4 for, fraud as a fiduciary, embezzlement, larceny. 523A6, that's for willful and malicious injury to a person or property. In a chapter 7 that applies. There's also I didn't put it on here, 727 objection, just a general, I said 727 is the section that's on discharge. So, but there's a 727, what we call a 727 objection. And that's like, I'm not objecting to this debt, I'm objecting to the whole case. Like, your case was fraudulent when you filed it you're trying to commit fraud on the court, those big, broader kind of things. A lot of times that might be filed by the United States trustee, or, a lot of times when parties will come in, maybe they have a 523A2 claim. I see it a lot. They just throw everything. 523A4 ain't got nothing to do with it. 523A6 ain't got nothing to do with it. 727, they just throw everything in there. And I got to spend a lot of time dealing with those, but, addressing why those don't apply. All right, so like I said, to get a discharge, there's things that, the debtor has to do. And these things right here, these are things the client has to do. It's not something I can do for them. They have to go to that 341A meeting of creditors, show up, answer those questions. They have to do, I mentioned that there's a pre-petition course that they have to take. It's about 30 minutes long. They can get it waived. They can get a fee waived. There's a little fee with them normally. If a lot of my clients, they can get the fee waived because of low income. The courts can waive the requirement on those. It's extremely rare circumstances. The ones I've dealt with before were usually a long time ago when I had represented some clients when I was in Texas. They were, out in the Middle East, and they couldn't do it. Post-petition debtor education course. So after you file your bankruptcy petition, before you can get your discharge, there's a second course that they have to do. We call it second course or debtor education course. They have to do that one as well. That one's a little bit longer, generally takes maybe a little bit longer hours or so to do that one. Let's see how we're doing on time. I don't think I see any new questions. How about a poll, Christy? And I'm going to look for questions.
Sure. Do you participate in online discussions of legal issues with other attorneys? Yes or no?
All right. Yeah, I was wanting to get an idea. So there are organizations like I'm a member of. There's ones I'm not members of, but there's a lot of like ABI, which is the American Bankruptcy Institute. There's one for debtor attorneys called the National Association of Consumer Bankruptcy Attorneys, referred to as NACBA. There's other ones I know for creditors and all kinds of different people. So, if you do, there's a Facebook one that's out there that's totally free. Anybody can get on there. So, if you're thinking about filing bankruptcy cases, there's a lot of places you can go and participate in online discussions. And, I go on there sometimes, answer questions. A lot of people I go in and ask questions, because no matter how long, if you've been practicing law for a long time, I know you'll agree, things will come up. I mean, most of the stuff, it seems like you've seen it all, and next thing you know, it's not. All right, let's do a couple of questions. If you have an exemption for X dollars for tools of the trade, but your tools are worth a lot more than X, then what happens? So if you have an exemption and you can't cover it, then let's say you were able to use your exemptions, but there were still like $5,000 that I couldn't cover with my exemptions. So the trustee, normally what the trustee will do is say, hey, hand over those tools and I'm going to go auction them. And as everybody knows, you're not going to get much at an auction for stuff. So you definitely don't want that to happen. So what I do is I go back to the trustee and I say, hey, let's work out a deal. And can I give you some cash instead? And maybe, you know, my client needs to go borrow some money from mom or pop, or maybe he had, you know, a retirement account or some other kind of account or whatever that was protected, but he's like willing to say, hey, I'd rather, or maybe has enough equity and he can get a HELOC or whatever, and he can go do something and come up with the money and pay the trustee. And a lot of times, you know, they'll even take, you know, less than 100 cents on the dollar. It's one of the, like everything, you know, it's just stuff is negotiable. But, you know, if there's a specific exemption, like under the federal exemptions, maybe there's a specific exemption for something, but then there's also like wild card that might be applied. So if you have an exemption for X, but, you know, you still have some wild card left over, then you can use that on there. But yeah, if there's nothing left and you just can't cover it, then they're going to have to pay for it. And then the trustee is going to send out the notice. How much does a first course typically cost? These are a couple of questions. Are the courses online and do they cost? There's a fee for the courses. They can apply for a fee waiver for the courses. There's a list. If you go to the Arkansas Bankruptcy Court website, there's a list or a link on there somewhere, and it has there's tons and tons of course providers that do it. Generally, you know, they're going to cost between $10 and $25, $30 per course or something like that. And a lot of times you buy a package kind of deal. But like I said, it's been a few years since I've been working at Illegal Cows that my clients just qualified for the waivers on those. And if you use the bankruptcy software, there's some things that they can do with those where they package a deal where it's like you can pull credit reports and get those courses and all that in one ball of wax for, you know, one fee, which is really great. Medical bills notoriously late in being issued. How do you handle discharge of medical bills from treatments that occurred prior to filing, but the bill does not come in for over a year? I've seen medical bills coming in a year after the death of a client. So like I said, if they, you know, if they got some treatment, list it, and you just put in there how much it is. I don't know. There's on the form, there's a place for you to mark. It's like, you know, the amount is unknown or that you disputed or something. The best thing is if you think anybody might owe you owe somebody anything and you just think maybe they think it, you don't agree with them, but for some reason they think you just list everything, it gets discharged. If it was incurred, regardless of when it was billed, if the debt was it goes from, you know, as long as the debt was incurred. Can a creditor enforce a judicial lien on discharged debt? So if not exactly. I'll talk about judicial liens in a minute. What bankruptcy form do you recommend if one wants to get back into doing bankruptcy? I mean, the bankruptcy forms are the bankruptcy forms. I hesitate. I mean, you can give me a call and I'll talk to you about software that you can use out there. There's a lot of software out there. But you know, it definitely, if you're going to be doing bankruptcy, there's software out there. So I'm sorry about that. I'm going to pass on doing marketing for them. But I mean, I've used several of them, and you know, they all have their pluses and minuses. All right, let's see. What are we on time? Oh, we're getting close. I'm going to jump through here real quick. So one of the things that bankruptcy does is it helps you deal with secured property. So if it's regular secured, not mortgages, but other secured property like cars and stuff, then they can either surrender it in the bankruptcy. They can just say, you know, here's the keys and walk and go away, and they won't have to pay any deficiency judgment or anything like that on it. They can reaffirm it. That basically says, hey, I'm entering into a contract that says, you know, that old contract we have, I'm still liable on. I'm still having personal liability on this debt. They can redeem it. That is, like, let's say they have a car they owe $10,000 on, but the car is only worth $4,000. They can pay the replacement value. They can pay the $4,000 for the car. or they can do what's called retain and pay. Basically, that's kind of like, it's not something really that's in the bankruptcy code, but basically it's like, as long as you keep it, they keep paying for it, and then generally creditors are not going to, do a repo on it. They just they want the money is what they want. Residential mortgages are different. One, you can't do a redemption on them. They're just excluded. So if it's a residential mortgage, then no redemption is allowed. Similar to the vehicles, though, they can surrender it, or they can do this reaffirmation agreement on them. There's, again, pluses and minuses to doing reaffirmation agreements. I generally recommend not doing a reaffirmation agreement because you're no longer personal liable on the debt. The creditor can still, they still have the lien against, whatever the property is or mortgage or what have you, but, they no longer can go collect any deficiency against the debtor on that. The retain and pay, like I said, it's as long as they keep paying for it, normally they don't care. There also becomes some challenges sometimes because, let's say the mortgage company, you just keep paying them, but you didn't do a reaffirmation agreement. And now they're saying, well, we're not going to talk to you. And so it's not universally great, because that can cause a lot of problems if your mortgage company won't talk to you because they're saying, well, you're not really on this or not. And case law out there is squirrely on all that. Judicial lien avoidance, I said I'd talk about that. So if someone goes and gets a lien from they go and they file, in Arkansas, let's say they're in Pulaski County, and they go and they get a judgment on a credit card, and my client lives in Pulaski County and he has a house, then they get a lien on the house as long as they, they go to circuit court. And wherever you are in Arkansas, but I know in Pulaski County, it's kind of like applies to the whole state. So they get that lien. The debtor comes in and files bankruptcy. He can get that lien basically avoided out by following this 522F. And basically, if his equity and his the secured loan on it covers it, and basically you can avoid the lien. It's a little bit more complicated than that in terms of doing math, especially when you have multiple liens on it. But so the key word is that kind of that down at the end where I say if the exemption would be impaired by such a sale. That is, if the value of the house, I have some equity in the house, and I'm not going to be able to use my exemption on it because your lien is digging into mine, kind of, so to speak, if you will. Time between filings. This is a kind of major thing. If you have a client that files a case and then it gets dismissed within a 12-month period, that automatic stay kicks in, but only for 30 days. And then if they have a second case filed within that same, dismissed within that same period of time, then they don't even have an automatic stay. So the automatic stay isn't there. So what I have to do is I have to go file a motion to invoke stay with the court. And, parties can object to that. Maybe they're saying, hey, this person is an abuse. I had a foreclosure and then they got their case dismissed. I had another foreclosure, they're getting dismissed. And, they're just abusing this to keep me from doing this foreclosure that I have absolutely, I have a right to. And then, they argue in front of the court, and the court might say, hey, you get a stay, but it doesn't apply to that mortgage lender who objected. And then in the first scenario, you just file a motion to extend the stay. So if you only have 30 days, like, the first thing I'm filing after I file my petition is a motion to extend the stay to get the court to extend it for the remaining life of the plan. Then there's, if a case is voluntarily dismissed, and there was a motion for relief from stay that was filed in that case, then there's a 180-day time bar. They can't refile a new case for 180 days. And again, it's to prevent abuse. I mean, somebody, a mortgage lender goes in and they file their relief from stay, and the court says, yeah, you get relief from stay. Debtor gets his case dismissed. He says, hey, I voluntarily dismissed my case, and then wants to turn around and refile a case. It's like, hey, man, you just, they got their stay in, and we don't want to let you abuse the system that way. So let me look back at the questions real quick. Do you mean there's bankruptcy software other than Best Case that a solo practitioner can use without the high cost? There's a lot of bankruptcy software out there, and there's some software out there that is free if you're doing pro bono case. You don't even have to pay anything for it. But like I said, give me a shout, and I'll talk to you specifically about my experience. I'd be happy to offline. So then lastly, on this time between filings. So if a debtor does get a discharge, they can file another case, but it depends upon how long they wait that will determine, and what kind of cases they file, that will determine whether they can get a discharge in the new case. So if the new case, this little chart is just like, if you filed a chapter 13, you got a discharge, and you got to wait 2 years to file a new chapter 13 if you want a discharge in that 13. So people can't just go out and get a discharge and then, run up a bunch of debt and 6 months later file another one. That's to prevent that kind of abuse again. Credit reporting, I mentioned a little bit of this. Chapter 7 can stay on a credit report for up to 10 years. Chapter 13 for 7. Discharge debts will show a zero balance. Credit scores. People ask me a lot, what's going to happen with the credit score? I don't know. Bankruptcy itself is going to lower the credit score, but now you're discharging debt, so your debt to credit ratio is going to be better. So it's gone. I've literally had someone come in and show me 30 days after they filed bankruptcy, their score went up. But I can't say, and those are weird algorithms, but they can start, building their credit as soon as they're done right after that. So that brings me to the end. Do we have another poll? I don't remember. I forgot to ask you.
I believe we do. Let's see.
I try to leave you time. You can do your poll. That's all right. Because I just realized the time again was running really, really to the end.
If you want to look, there were some questions. I don't know if you saw them in the chat box that didn't go into
I didn't see
the announcement about putting them, but they are kind of long, so I don't know if we can get to them today.
Yeah. Go ahead with your poll.
Okay. Well, your last poll was, after viewing this presentation, I will likely file a Chapter 7 bankruptcy case.
Okay.
And so people are answering that one right now.
Yeah, I included that last one there for all of you guys. I learned enough. There's a lot going on. As Judge Taylor, I've heard him and many other people say, it's either you are a bankruptcy lawyer or you're not. Don't kind of be one. So let's see. Someone said in no asset Chapter 7 case, are they still covered under the discharge if you don't list them? Yeah. So yeah, medical bills, if they're not listed, they're still discharged. Hypothetical. I don't think we have time for that, but you can contact me offline if somebody wants to ask about that hypothetical.
Okay, I'm ending this poll, and there's our results.
And if I will admit, if you take pro bono cases or whatever, I mean, and you can call me, even if you're a regular for-profit practicing bankruptcy out there and you want to call me, or, we all talk to each other, especially, creditor attorneys talk to each other a lot, and debtor attorneys talk to, one another a lot. So we can learn as much as possible.
Okay, and I think the survey should just pop up, but again, once you start to close, or once it's over, but if you don't get the survey, you will get an email tomorrow and have another chance to take it. So don't worry about if you don't get the pop-up today. Just a reminder, I'm about to send everyone out an email with the slides, so you will have all the slides. This was recorded, and it takes a little while for Zoom to prepare that, but once I get that, I will post that to YouTube, and we'll share it on social media. We can't give CLE credit to anyone who watches it, the recording, but it is available if you want to share it or rewatch it for reference. And again, I'll be sending out your CLE forms, and please send them to CLE@arkansasjustice.org. And Doug, do you have anything else?
No, thanks a lot. And again, I really mean it. If you have something going on, feel free to give me a shout, and talk to cases, hypotheticals, and things like that. Obviously, don't break client confidentiality. And I can talk to you also about that software stuff, or about boards that you can go to find out about other people talking about bankruptcy. But other than that, welcome to learning a little bit about bankruptcy, and I hope this helps you in your practice. If nothing else, just to issue spot in your own practice some bankruptcy issues that can come up. Thank you.